All right, we're going to begin a series of lectures for what would have been our April 11th class. We're covering chapters 13 and 14. The first one chapter 13 has to do with preliminary stages of a prosecution, and it begins with what happens after you are arrested. And the when someone is arrested, they're uh, supposed to be brought as soon as practically um, before a judicial officer for what is called um, an initial appearance in Alabama law. Sometimes it's called an advisement because what happens there is generally you are advised of your rights, your right to an attorney, and your right to make bail. And most importantly, they're supposed to the judicial officer, the judge, is supposed to ascertain, are you the right person who is alleged to have committed a crime? Was the right person arrested? And they want to be sure that you know and understand the charges against you. So that's the initial appearance. It's supposed to happen as soon as possible. Generally, that might, the goal is within 24 hours. That's difficult to do if there's a weekend intervening in your arrest, which is very common. Friday nights and Saturdays, for whatever reason, tend to be the uh, biggest volume of arrests. And on Monday is when you go in front of a judge. Um, and sometimes you'll hear judges say, I've got to see the quote, jail cases, end quote, um, today. And what that means is he's doing initial appearances. Those are usually done via video now. There'll be a room at most jails where there's a video uh, set up, and the person will be brought in front of that video camera. They'll be able to see the judge can see them, hear each other, and what used to be a matter of bringing the people to the courtroom is now done um, in that way. Um, so the those usually happen. Let me say this. Sometimes they're called 72-hour hearings because under Alabama law, if you are not given an initial appearance within 72 hours, then you're you have to be allowed to make bail at the minimum amount of the bail schedule. So it's supposed to happen as soon as possible. The goal is within 24 hours, but it must be within 72 hours. Hence, the term that's used of the 72-hour hearing. So, so what happens is the judge asks your name. Do you understand what your charges are? Do you have a lawyer? Do you intend to hire one? They ask, do you believe that you would qualify for appointed counsel if you're indigent? In other words, can't afford a lawyer. And if you suggest that you are, you'll be given some document to fill out that um, allows the judge to make that determination based on your income, assets, your fixed expenses, and other liabilities um, in determining sort of a net disposable income that can be used to hire a lawyer. And you can be determined to be indigent or partially indigent um, and required to pay something towards your lawyer. The most common thing now is to, if you're appointed a lawyer, to charge back a portion of those fees if you're convicted. Of course, if you're not convicted, um, the court can't assess those attorney's fees against you. If you're fortunate enough to be able to afford your own lawyer and you're found not guilty or acquitted, you're still out that money. Nobody pays you back. There's some very limited ways to recoup your money um, in the federal system and maybe other states, not in Alabama, but in the federal system. It's called the Hyde Amendment, HYDE. it was named for a senator that passed this bill that said basically if a charge is brought in bad faith and somebody prevails, that they can apply to have their attorney's fees reimbursed by the United States government. The most, I guess, well known of those cases was the prosecution involved the prosecution of a former senator from Alaska named Ted Stevens. You can look that up and see something about that very troubled prosecution and how it fell apart, and how ultimately there seemed to be more going on than just the good faith prosecution of crime. And Ted Stevens prevailed on his Hyde Amendment claim. So we're told that in the olden days, generally property or cash had to be posted as a surety that a person would return to court. That's one concern of the judge, is what amount of bail will guarantee your return to court at the appointed time. Next is whether or not you pose a danger if you remain at large, that is, not in custody. Eventually, the norm, it would appear in former times, was that people tended to either have the money to post property or cash, or could round that up, or they just stayed put until trial. But eventually, the professional bonding companies came online, and that probably is the most common way people make bail now. You pay some percentage, generally 10% or maybe 15% of the amount of bail, to a professional bonding company, and they will sign a surety for your appearance, such that if you don't come back to court, then that bonding company will pay whatever that bail amount is. And it's like insurance. You know, they collect these fees for bonding you out and expect that you'll show up, and the next person, and occasionally they have to pay a claim. So it's like paying insurance premiums for the bonding company. I mean, it's your money, you pay it, but they're called upon to pay a bond forfeiture occasionally in the full amount. There's a lot of process that goes on before that, like them being allowed to try to find you and turn you in. But there can come a time when those efforts have failed and the bonding company has to pay. There's some discussion here about the Bail Reform Acts that we'll get to in just a minute, but I want to make sure that you understand that the protection against excessive bail is part of the Eighth Amendment, which also protects against cruel and unusual punishment. It also protects against excessive bail. And there's no bright line about what's excessive, but that Eighth Amendment guarantee is what drives, and what is driving now, this latest round of bail reform to very seriously limit money bail as a means of doing business, because oftentimes what that does is allow people of means, limited or great means, to post bail, get out of jail. And it leaves the destitute and poor, who may be innocent just as much as the rich guy, it leaves them in jail because they can't afford a fairly meager bond. So that's sort of the latest in the bail reform movements. But the book talks about a series of bail reforms, first in 1966, that set up a presumption of allowing people to be bonded out on their own recognizance, a a presumption that that is an adequate means of assuring your appearance at court. And then the further bail reform involved looking at specific factors. The Bail Reform Act of 1984, listed a number of factors that had to be met or considered by a judge in setting bail, whether to simply remand you, that is, keep you in custody without bail, very, very rare circumstances, having to do with a danger, if you pose a danger and there's no way to allow a person to be at large because of a record of being dangerous. So they can be released sometimes to the custody of persons, sometimes who will vouch for their supervision. They can be released with monitoring by means of an ankle monitor or something like that. But those, of course, require the defendant to pay for them, and they can be fairly expensive, sometimes several $100s over the course of a month for the maintenance fees for the equipment and the paying for the people who monitor it. That may be a contractor, or it may be a government agent like a community corrections or a probation officer, but nonetheless the government seeks to recoup that money by means of imposing that cost on the defendant, which is interesting because the real cost comes from having somebody in the jail with adequate staffing to supervise them, to feed them, and to be responsible for their medical care. So it's kind of like those, quote, convenience fees that you pay for paying a bill electronically. It's really the convenience of the person to whom you're paying the bill, because they don't have to have someone to take your money, count it, give you a receipt. You do it over the computer. Very little manpower involved in that. But nonetheless, they want to push that cost back on the citizens, and so far that has been upheld as constitutional. They also now impose bond fees in Alabama, and that is just again has been determined to be constitutional, but it is a really I think disturbing trend, because it ought not cost you to be able to exercise your right to be on bond, but those fees are typically paid at the end. So if you're found not guilty, it doesn't cost you anything. If you plead guilty or are found guilty, then it's imposed as court cost, and that can run to several $100s for the privilege of making a bond. It's just another way to wring money out of people. I could go on and tell you how much the civil and criminal justice system is laden with fees to fund itself on the backs of people, typically poor people, if we're talking about the criminal system, certainly, rather than just having it funded from general revenues of the state, like sales tax, property tax, or whatever. The legislature in Alabama certainly believes that the justice system should be a pay-as-you-go system. It reminds me of going to the fair and having to have tickets. You get a big roll of tickets and you can ride the rides. And that's kind of how the criminal justice system feels at times because of all the fees and costs of simply getting to the trial. We're not talking about fines or restitution. We're talking about a fee to make bail, a fee for electronic monitoring, etc. I want to emphasize one thing. The difference between the 1966 Bail Reform Act and the 1984 Bail Reform Act is in the federal system, the focus in the 1966 Act was simply how to assure your return to court, what amount of bail would ensure the defendant's appearance at trial. And the reform in 1984 allowed the courts to consider whether or not you could safely remain at large and under what conditions, and people who are regarded as potentially dangerous, in other words, preventing you from committing future crimes, those people could be detained pending trial. In the federal system, of course, you have the Speedy Trial Act that generally means that within a certain time of your arrest, with some exceptions, 90 days, the government has to be ready to proceed to trial. So you tend to sit in detention in federal court for a much lesser time. Of course, a strange thing that's happening right now is people are being detained because of the COVID-19 shutdown, and there's no guarantee about when the courts will re-up. Because of all these concerns about pretrial detention, you can be certain that when the courts reopen, that there'll be an avalanche of disposing of criminal cases, whether by trial or plea, so that people who are being held without bond can be released or moved from pretrial detention to a penitentiary sentence if that's what's going to happen to them. Or, as is the case with many cases, you move from pretrial detention to probation or community corrections or a split sentence or something like that. The danger is if you sit too long, you'll sit longer than you would actually have to serve for certainly misdemeanors and for certain, Class D and Class C felonies, certainly if they're nonviolent and first offenses. If you look at on page 255, 256, you'll see a typical bond form, and on the back you'll see additional bond provisions and certain conditions. Generally, the most important one is that you not commit a new offense. If you do, or if you are under some restriction not to go around a victim of crime or a person, or back to a store that you robbed or whatever. If you break those conditions, your bond can be revoked, which means that you are not on bond anymore. You're left in jail till your trial. Another thing that can happen is that your bond amount can be raised. So you have to post additional surety. Sometimes that guarantees that somebody has to sit, because generally the bondsman gets all your money that first go around. Then the another thing that can happen if you violate certain terms, especially if it involves not returning to court, is that you can be charged with new offenses. In Alabama, it's called a failure to appear, or FTA. That's a separate offense. And then in the federal system, in other places, it's called bail jumping. That is just not coming back to court, or if you leave the jurisdiction, flight to avoid prosecution is another offense related to not returning to court when you're supposed to under the conditions of your bond. And finally, the book mentions that you can be held in contempt. That's a pretty unlikely um, remedy for violating the conditions of bond because it just generally doesn't have much punch to it. Um, but if you have a generally what's called a bail bond revocation, you'll be the state will seek to revoke your bond. They'll file a motion, and if it looks like you violated based on the allegation in the motion, the court will issue an arrest warrant. You'll be arrested, brought to court, and advised of what is the basis of your proposed revocation, and then given a hearing as quickly as possible. And if it's proven to the court's satisfaction that you've committed a new offense or somehow violated the bond condition, then you can be put in jail without bond. Or the judge has the remedy of raising your bond or giving you a stern warning and sending you back on bond and telling you not to do it again. You're entitled to representation, to notice of what the allegation is, and to representation by counsel in a bond revocation proceeding. The next topic in this chapter is the preliminary hearing, which is one of two ways that probable cause is established for felony prosecutions. And the one is the preliminary hearing, the other is by means of grand jury. Alabama has a system that you either have a preliminary hearing or a grand jury proceeding. You're not required to have both. Sometimes you do have both. You have a situation where you're in custody and you have a preliminary hearing, and then later your case is presented to the grand jury. That's just kind of the way they double up on that. So a preliminary hearing has to be demanded within 30 days of when you're arrested. And then within that, if I'm not mistaken, 14 days after that, they have to have the preliminary hearing. And at the preliminary hearing, it generally is a one-sided presentation. The defendant is not going to testify because if he's innocent and we've got the wrong guy, that generally will become evident. Typically the testimony is offered by the one police officer, the investigating officer, or the arresting officer, and the scope of the testimony is simply to establish probable cause by identifying the person who's been arrested as the person that committed the crime, and that the things that they are said to have done, that they constitute a crime. So the preliminary hearing is held at the instance of the defendant. They request it. And the lawyer for the defendant can cross-examine the police officer and find out things about the case so long as those questions relate reasonably to the issue of probable cause. It is not a wide-ranging discovery tool. You'll discover in the next chapter just about how very limited discovery is, and it certainly there's not a lot of help in the preliminary hearing for obtaining discovery, unless the questions and answers have to do with probable cause. The prosecutor can rely on hearsay information in a preliminary hearing. They can also use evidence that might be later subject to being suppressed in violation of a person's right against self-incrimination or Fourth Amendment challenges. Those that kind of evidence can come in at a preliminary hearing. So the question becomes, or the book points out several reasons to have a preliminary hearing, because they're typically so perfunctory that there's not a lot of dramatic stuff that's found out, or stuff that you didn't already know or that your client might tell you. However, clients are not always forthcoming with their lawyers. Well, anyway, one of the reasons is suggested that for having a preliminary hearing is discovery, and yes, you do find out things that you may not know or your client may not have told you. The other issue is laying the groundwork for impeachment of witnesses. And what that really means is you're going to have this officer, or sometimes a witness, that you might summon, an alleged eyewitness or a victim, and get them under oath such that their testimony becomes practically speaking, a fixed entity, so to speak. In other words, if they say something under oath as being true, they can't change their account of what happened under ordinary circumstances, because diametrical things can't be testified to under oath without someone committing perjury or a great deal of suspicion being created about the person's veracity generally. So that's one reason. In other words, you want to nail down some information from a witness. The next thing that the book suggests on page 258 is the preservation of testimony, and there may be some circumstances where you want to do that as a defendant, such as an alibi witness, such that if they die or leave the jurisdiction, the state would have the opportunity to cross-examine them in that forum of the preliminary hearing, and that testimony could be entered into the transcript into a trial. But where this usually comes into play is the prosecution would have an opportunity to preserve testimony that they want. And so if you ask for a preliminary hearing, you would open the door to that testimony being offered, and the defense having the opportunity to cross-examine them, thereby making that testimony admissible in a trial. So let's say that's a prosecution witness, and nobody has let's say they give a statement, maybe even a recorded statement, a video statement, or a handwritten statement. And their testimony is not transcribed, or it's not preserved, or there's not been an opportunity to cross-examine them. That will not come into evidence at trial. So sometimes demanding a preliminary hearing it can backfire on a defendant, because otherwise inadmissible testimony due to the inability to confront an absent witness may be preserved because that person was at a preliminary hearing and a defendant had the right to cross-examine them. whether they did or not, they had the opportunity. So that typically, that issue of preserving testimony favors the state. So sometimes there may be reasons not to ask for a preliminary hearing. Typically, preliminary hearings are not done, quote, on the record, meaning there's not a court reporter present. And if a court reporter is not present, then there isn't an official record. So if you, the defendant, are seeking to have the preliminary hearing, often short, called the prelim, if you're the one who's requested the prelim for the purpose of preserving testimony for one thing, or more likely getting the officer's testimony preserved under oath, you're going to need to make a provision for a court reporter to be there, typically, at the expense of the defendant. So just not everybody has the ability or means to hire a court reporter for the preliminary hearing. Just like in misdemeanor court, where you have bench trials, in city court or district court, let's say it's a DUI, a lot of times you'll have that trial to get the officer's testimony nailed down. Obviously, you hope your client will be found not guilty, but if they're not, you've got that testimony. And if you do, if you plan to do that, you've got to have a court reporter there, because municipal courts and district courts do not have court reporters on staff. So at the end of the preliminary hearing, if the judge is satisfied that the defendant that there's probable cause to believe that a felony has been committed, they will order that the person be bound over to the grand jury. If in the rare occasion they don't believe that a felony has been committed, they will dismiss the charge. Happens very, very rarely. Once I had a case that was an interference with custodial rights, which is a felony offense. Be very careful how you deal with those circumstances. But the judge ultimately decided that that was not a criminal case, that somebody ought to file a contempt petition in a divorce court, but it wasn't an interference with custody situation. But, I know that lawyers say that once, twice in the course of their career, they have a case dismissed at the preliminary hearing. Very, very unusual. So the next thing we talk about is the grand jury. Grand jury is grand, as in Grand, versus petite. Those French words. And it's called a grand jury because it's a larger jury of people versus the smaller one, and the French word that goes with that. And those typically are what a petit or petit jury is, the trial jury of 12 people. The grand jury may consist of over 20 people, as few as 16, certainly in the federal system. And they are impaneled to hear evidence and decide whether or not felony offenses have been committed. That is often said that the grand jury investigates. What really happens is that the prosecutors make a presentation, again, with illegally obtained evidence, possibly. There's no Fourth Amendment there's nothing that bars evidence from being used in a grand jury that might ultimately be suppressed for Fourth Amendment violations or Fifth Amendment violations, or Sixth Amendment violations for that matter. And they can use hearsay, and typically the presentation is one officer testifies about the facts of the case, oftentimes, testifying to what the victim told them, to what other officers told them, that kind of thing. Grand juries are held in secret, and the defendant is not often invited. There's some rare circumstances. Okay, a defendant can demand to be there, but oftentimes a case will be presented to the grand jury without notice to the defendant. There's no requirement that the DA give notice. But if for whatever reason a person, and if they have a lawyer, it'll be a very, very rare circumstance where they want to go to the grand jury, they will certainly need to let the DA know about that way ahead of time. Not very common, mainly because it allows the DA to have a shot at cross-examining this person, and the client may have a lot to say, a lot they want to say, but a lot that they might not want to say. And the trouble is, you do not have the right to a lawyer in the grand jury room with you. We'll talk in a minute about how it is that a person can be represented, but the lawyer can't come in the room. Same thing with a witness if they're not a suspect. But let's back up. We've skipped over how a grand jury is selected. They are selected generally the same way that trial jurors are summoned to court. In Alabama, what happens typically is that they take a civil jury venire, that is to say, the list of people who have been summoned, and those people, when they arrive, several, at random are selected to serve on the grand jury, and if they are qualified. Now, what makes you qualified to be on the grand jury is, yes, on page 260, you have to be a citizen, reside in the jurisdiction, be over the age of 18, and have no felony convictions, and then this intangible, be a person of honesty, intelligence, and good demeanor. Okay, so people who are summoned for jury duty have to be screened for those basic qualifications, and then can be further reduced to that number of 20 plus, or down to 16. Now, what people cannot be excluded from grand jury based on race, gender, national origin, anything like that, just like a trial jury. But we're told in the book that a particular grand jury cannot generally be challenged for a lack of cross-section of the community. There has to be some systemic exclusion of people based on what are called suspect categories, race, national origin, gender, etc., or age for that matter, as long as you're at least 18. In Alabama, I know in Morgan County there was a successful challenge to grand jury composition by means of the way that the foreperson of the grand jury was selected. They were always selected by the presiding judge, and it had to be somebody that the presiding judge knew, or typically that's how it worked. And so what happened was, over the course of many years, there were never any grand jury foremen who were minority. They were all white males. And Levi Pace, Pace, was that case. And I remember that evidentiary hearing on a Rule 32 challenge, post-conviction challenge, and they brought 4 or 5, maybe 6 former DAs going back to the 60s, when black people first were allowed to serve on juries. And then they brought forward, had there ever been anything other than a white male serve as the foreman of the grand jury. And the answer was no, just based on the fact that the judge always picked their friend or somebody they knew, or just by virtue of either venial or mortal discrimination, they just chose somebody that quote, looked like a good person. And a white man, certainly at that stage, was always going to pick another white man. And that's the way it played out. But there has to be, in order to challenge the grand jury composition, there has to be an allegation and proven of systemic discrimination. All right, so there's that, as we talked about, one-sided presentation to the grand jury. And the grand jury then, by a vote of at least 12 people, may return an indictment, and those indictments are drafted by the DA. And if they find probable cause based on the vote, then the foreman signs the indictment, and it is signed by the district attorney and then presented in open court, and the judge signs the indictments as well, generally setting bond for the person who would likely be arrested on that felony indictment. If the grand jury does not believe that a person has committed a crime, then they return what is called a no bill, N-O space B-I-L-L, no bill, which means basically they don't indict. If they indict, it's called a true bill. If they don't indict, it's called a no bill. A prosecutor can resubmit a case to a different grand jury later, so long as the statute of limitations is not run. Double jeopardy doesn't attach until the trial actually begins. And so anyway, you can have successive presentations to the grand jury. Now, a grand jury is impaneled in order to consider indictments presented by the prosecutor, but they're not limited to what the prosecutor gives them. They can issue not indictments, but they can issue charging instruments based on their own investigation. Those are called presentments as opposed to indictments. The grand jury can issue subpoenas and summon 4 documents, 4 witnesses, and so there can be rare circumstances when a grand jury not only considers what the DA offers, but can conduct their own investigations if they believe that crimes have been committed. Very rare. In fact, I've never heard of it before, but I'm sure there must be examples. Um, so, and another thing that grand juries do in Alabama, just an odd duty of the grand jury, and you will see this on the test. I promise you. This is your reward for listening to this lecture, because you will know the answer to this question. They they tour and inspect the county jail. The grand jury is charged with inspecting the county jail for humane conditions, cleanliness, and so on. And so, literally, if you're on the grand jury, at some point during the course of your grand jury term, you go and walk through the spaces at the um, Morgan County Jail or any other county and uh, return a report that the jail is in good order or not, in which case, um, I suppose the presiding judge would take note of that. And I don't know. It's just oddly enough, it's never happened. In other words, in Morgan County, when the federal courts put Morgan County under a court order and deadline for constructing a new jail with adequate space, and the grand jury was not the engine of that change. It was prisoner lawsuits that drove that. The same is true of the feeding provisions for inmates. It wasn't like the grand jury took that on. Um, Prisoners litigated or organizations litigated on their behalf. So that's something they do in Alabama, but it generally is a neglected um, activity. I mean, they do it, but it's just perfunctory. All right. So, what are the rights of witnesses before a grand jury? Um, they cannot simply refuse to cooperate because they don't want to. They can be held in contempt of court, put in jail until they testify, to coerce their testimony. Uh, a a witness may invoke his or her right against self-incrimination. Likewise, they can invoke their right not to produce things that they can challenge a subpoena on the basis of Fifth Amendment privilege as well for producing documents or tangible things. We discussed that you don't have a privilege against complying with a subpoena unless your compliance, the fact that you have something, its delivery, it's coming from you, would implicate you in criminal activity. Not the contents of documents, for instance, but the fact that you have a document or thing that was stolen or contraband that's illegal to possess. All right, so back to um, what a witness or certainly a suspect or a defendant, if they choose to go to the grand jury, if the defendant chooses to go to the grand jury, a witness would be there under subpoena. They can't have a lawyer present with them. There's no Sixth Amendment right to have a lawyer in the room with you. You may, at any point during the questioning, leave the grand jury room, repeat the question to the lawyer who's outside, and then, based on the advice of that lawyer, come back in and assert the privilege against self-incrimination or not. But that's the only basis for objection, and it has to be done in that very cumbersome fashion of going out of the room, consulting with the lawyer, coming back in, and either asserting the privilege or answering the question. Uh, Grand juries can sometimes, in certain jurisdictions, grant immunity. Um, that happens in different ways in different jurisdictions. Um, for testimony. But that's very unusual. Okay, so that little section talks about grand jury secrecy, and it's very, very important. You can be charged criminally for violating grand jury secrecy. You can be held in contempt. It's a very rigid rule. There's a Supreme Court case that came out just last month about a very old grand jury proceeding in the 40s that involved an infamous murder where the persons involved, well, four murders. There were two couples who were abducted and lynched in Coweta County in I think that's right, in the Atlanta area. And there's a great deal of historical interest in that case, and a historian sued for unsealing grand jury records. He died in the process of that litigation, and his wife took over the litigation. And there was amicus from various groups, typically historical associations, that were seeking to have a court recognize that grand jury secrecy could or should be waived in exceptional circumstances. And this was a situation where there were no persons charged as a result of these fairly infamous and egregious crimes. And this historian was attempting to write a book about that. But the 11th, I might have said Supreme Court, it was the 11th Circuit, just released an opinion upholding grand jury secrecy, even though there might well have been a good deal of sympathy for the object of that, seeking that grand jury testimony. All right, so we'll move on. I will stop this video and start another for the remainder of this chapter.